Second, people. All right, let's go ahead and get this thing rocking and rolling, shaking and baking. I got to move over 1 second. I got to make sure I get the other question thing for me live. And hold on. Of course, gotta. All right. 1 second. Test. Let's get going. Okay. I want to thank you for joining me again on Disability Talk Live. My name is Attorney Anthony Reeves. So let's just go ahead and get rocking and rolling. Today I wanted to talk a little bit, and just let me go ahead and throw out a couple of things. This is typically, for those of you who are joining me for the first time, let me tell you how I operate. Typically, I have a general topic that I address, but what I do is I do give you the opportunity to jump in and ask me any specific questions in particular. So here's the thing I do ask though. When you put a question, ask a specific question. Don't just like throw out general words and asking me to kind of expound. If you have a specific question that you'd like for me to address and so forth, please make sure you kind of lay it out accordingly, so that gives me a little bit better insight. So let's go ahead and talk about what's the underlying topic of discussion for today. Today, my main focus from now, and pretty much we're going to be broadcasting, my shows typically run about half an hour, so 4 to 4:30. Today's show really is focusing on your case. And this may seem kind of weird or an odd topic to address, but when I say focusing on your case, the main discussion I have is getting people to appreciate the fact that when you're going through the disability process, it is important. It is very important that you focus on your case. Now, before I go any further, I had a question already. Dennis asked, what are the odds of getting approved? And again, that's a little broad, and I don't understand what you're asking. What's the odds of getting approved at the local level, at the hearing level, at the appeals council level, at the federal court level? What level are we talking about? And so you got to give me a little bit more information before I can actually answer that question. So getting back to the original topic here, when you're applying for the disability process, what you probably will realize is there are a lot of resources out there. Okay, there are a lot of resources out there that can assist you while you're going through the process. But let me take a quick break here and stop and answer Dennis's question. I'm going to say this, Dennis, so don't take this the wrong way. I always tell people, don't focus on the odds, focus on strengthening your case, because when you're at federal court, there may not be a whole lot of extra that you can actually provide at that particular instance. So when they say, what are the odds of getting your case approved? It just depends, because the reality is that it depends on what's in your evidence. It depends on what legal arguments are being made. It depends on whether or not you're going before a judge that tends to be a little bit more plaintiff friendly or not. There's way too many things out there to give anybody an accurate indication of what the chances are getting approved at the federal court level. If you're at a court that tends to not be very plaintiff friendly, your chances may not be great. If you're at a federal court where they are more plaintiff friendly, they may be better. The reality is that once you're at the federal court level, they're looking at things a little different. What they're looking at is whether or not, in terms of, they're looking at it from the standpoint of, did the judge make any legal errors? And so the key really is what legal errors were made in your case. Now, legal error is not just, were you approved, or, the judge was wrong not to approve you. That's not really what the court is focusing on. What the focus is in this particular instance is that you are laying out specific reasons in accordance with the law that the judge did not do something appropriate. For instance, maybe there was a medical source statement in your file that gave a detailed breakdown of your conditions by your treating doctor. The judge did not mention it anywhere in your file. So as a result, a legal argument could be made that the judge failed to give weight to the opinion of this particular doctor. And you have to give the case law supporting why what that judge did was wrong in terms of how they did it. But then you have to take it a step further. If you don't know, you don't know what the law is of your land, and this is where it gets tricky. This is why it's really important to have an attorney in federal court who knows what the law of the land is for that particular area. Some federal districts, the law with regards to certain things can be a little bit trickier. You don't know what the basis is. You don't know what the case law is for that area. Some laws and some things tend to be a little bit more user-friendly, and other, it all depends. And to go to your second question, I have no clue how much back pay you get. It all depends on, you know, what happens in terms, if you're even found disabled at federal court level, whether they approve it there, whether they send it back to the judge for another hearing, or whether or not they can approve it there or pay you there. Too many variables. So I always tell people, when people ask me those two big questions about what's the chances of getting approved or how much back pay, I tell them, why don't you focus on the most important thing for your case right now and trying to win the case right now. All the rest of that stuff will work itself out later. Focus on what's going on now. And the fact that you've been waiting for 4 years, I understand that. But you know, the reality is, I don't know how much if you're getting, if this is SSI, if this is DIB, if it's DIB, what your monthly amount is, if there's any offsets or anything like that. There's way too many variables for anybody to tell you what it is. So a lot of times when I'm telling my clients this, I tell them my responsibility is to give you the good, the bad, and the ugly. And part of my responsibility giving you the good, the bad, and the ugly is to help you manage your expectations. And so my philosophy, and this is one of the things that a lot of times reps and their clients tend to bump heads in. You're thinking the long term in terms of what happens if you get to that end result. The representative is looking short term. They want to get you to the next step first. So they're not worried about all that other stuff, because to be honest, that's gravy if you get there. They're not focusing on step 5, 6, and 7. If they haven't gotten past step 1, they don't want to really talk about 4, 5, and 6, and 7, because if you don't get past 1, the rest of that is irrelevant. So they want to get past 1, and they want to do what they can to get you. That's where their energy is going to be. I want to go to Mark L. He says, does Social Security offer any attendance services? None to my knowledge. And like a caregiver to help you, or if you can't perform, it just, to be honest, I don't think Social Security does. And to follow up, Dennis, there's no way I can look at just those little bullet points, because like I said, in order for an attorney, and this is a good lead in to, because I know we talked about focusing on your case, but let me talk about something else. When you're trying to determine what your chances are and what your odds are and so forth, and sometimes, you know, there's a lot of places out there now where you can blog, or, you know, check on blogs or check on groups, and you try to get an idea. And I always tell people, here's the problem. As attorneys or as representatives, we don't deal with generalities. We deal with specifics. You telling us the specifics is not specifics, okay? Because you saying extreme limitations, I don't know if that's your interpretation or what's actually in your medical records. Also, if in your medical records there are different varying interpretations, like one person said extreme, another one says moderate, one says severe, another one says none. A lot of times what happens, and this is where, you know, people come to me, and I've had this happen to a federal court level. They'll say, I had a great federal court case, the judge really messed it up. And then I'll tell them, send me what you got. And then they'll send me this record that's either huge or real thin, and I'm looking at it and I'm like, okay, here's the problem. You're zooming in on this one particular thing. I'm looking at the whole picture because that's what the judge is looking at. And I'm going to tell you that looking at it from the whole picture, here are the problems that you have. And if those problems, if the case law in your jurisdiction doesn't help you overcome those problems, you can make the arguments, but the chances of winning is not the best in the world. And so so I always tell people, especially you'd be surprised the number of emails that I get or chats on my chat pages and so forth like that, where people will say, I got this, what happened in the court? What do you think my chances are? And I stop them and I say, let me tell you something. I am a representative, and as a representative, I don't deal with generalities. When you say, what are my chances? Okay, what are my chances? The reality is that I don't know unless I look at your complete file, not a part of the file, not the portion of the file you think I should see, not the part of the file you think is helpful, your entire file, because I need to see what the judge looked at. Because if there is something in there as a basis to support what the judge had, I have to be able to overcome that in court. If I can't do it, I may not be the one for you. If somebody else thinks they can, great. The reality is that when you start going into federal court, and this is the thing that I tell people, and this thing that I've been trained over the years, if the courts become more conservative, the higher up you go. What does that mean? That means it becomes harder to show that the government did something wrong. And if you go to a representative at the federal court level, and they've never represented you before, that means they have to take whatever happened before that they had no control over and work with that information in federal court. And because the standards tend to be higher, the higher up you go. So you get to a judge level, the judge denies you. when you go to the appeals court, they don't look at it as if they were sitting in the position of the judge. They're looking at it from a clearly clean standpoint of, did the judge apply the law wrong? Plain and simple. If they believe that the judge didn't, taking it in the federal court becomes tougher. Not because, and this is the thing I always tell people, because sometimes I'll have people come to me and say, attorneys are afraid to take it. I said, stop right there. Most attorneys are not afraid to do anything. They're in the business to make money. So the reality is, as a business, sometimes they're looking at it from a legal standpoint and asking themselves, do I have a legal ability to be able to make this, and do I have a financial ability to be able to make it? The two have to go together. You know, if they appeal, they may not want to take a case in the federal court because, for whatever reason, the person may have some offsets. Okay, they may have some offsets that may result in them not getting paid attorney fees. If that's the case, they may not want to take it. The standard might be tougher, meaning if the reason why they're appealing would be based on an area of law within that circuit that is not very plaintiff friendly, and your facts aren't one of those cases that can overcome that, they may not want to take that risk. So the reality is the fact that they don't want to take, when people say, I hear a lot of attorneys don't want to take a case in the federal court, it all depends on their business model. You know, if their business model is one where they only do case work with cases at the Social Security level and none in federal court, totally understand. Okay, if the case is one where looking at the facts of itself, that they didn't do a lot of development with the case before it got to that point, they may make a determination that, hey, you know, this is not one that I'm going to take into court. Now, Michael is asking, I was approved on appeal, and let me see. I have an upcoming CDR. I have no clue what my approval was based on. I call the 800 number. How do I find out what I was approved on appeal? Okay. What you should do is go to your local office. Ask them for a copy of your CD. Your local office can give that to you. So if you go to your local office, tell them what you want is a copy of your CD that has your medical evidence and determination from your last approval. If you're at the CDR level, they can usually provide you that there, but just contact your local office and they can provide that information to you. This way you can know, you can have that information, and you'll know exactly what the basis of why they approved you. And this will give you some insight going forward. So this way you'll know kind of, you know, how to address the situation. Okay. Now, going back to our discussion, keep questions coming. Of course, it is 4:12 here on Disability Talk Live with Attorney Anthony Reeves. We've got about 18 more minutes, so you got to get those questions in if you got them. Now, one of the reasons why I wanted to talk today about focusing on your case is because of a few things. A lot of times what happens is when people are going through the disability process, they find themselves reaching out to people in different groups to get guidance about the best way to handle, you know, how others handle their case. The reality is we all love to talk to people who are similarly situated, because it provides us some comfort to know that we're not going through this process by ourselves. Big ups, respect, got that. I'm right there with you. However, you need to be very careful, because a lot of times, sometimes people don't realize that they may actually not be helping you. And what do you mean by that? Like when people, I cannot tell you the number of times I've had people who've said that they talked to this person who said they got approved, and they don't understand why I haven't been approved. Here's a few things you need to be aware of. First, you really don't know why that other person got approved or not. That person will tell you that they know definitively, but if they didn't have a copy of the decision, if they have a copy of the decision and they can kind of tell you, that's great. But the reality is that in some instances, the person may not be able to definitively tell you exactly why they were approved. So it's important for you to understand that because of that, you may not have a true appreciation. Okay, you may not have a true appreciation as to what was the basis, okay, as to what was the basis for why they got approved. So I say that not to be funny and not to be, you know, stank about it. It's just that a lot of times people, they get so caught up in the fact that somebody else got approved that they feel like they should have the exact same thing. So I always tell, so one of the first things I tell people all the time is make sure you realize that just because somebody else got approved, that doesn't necessarily mean that they know exactly what was the basis for their approval. The other thing is, you don't know which workers was handling their case. And that's not trying to be funny or smart or being flippant, but the reality is that when you apply for the disability process, your case gets assigned to a particular worker. The same worker doesn't get your case all the time. So that means, you know, whoever was handling the person's case who told you that they were approved, your case may go to somebody else. You don't know every piece of medical evidence that's in that person's file. And that's not me trying to be flippant. I'm not trying to be nasty. I'm not trying to be disrespectful. And I know some of you are going to be like, dog, Attorney Reeves, why I gotta be all that? I say, I'm not trying to be mean when I say this. It's just what happens is that a lot of times people will, and sometimes people don't realize that they're doing it when they're talking to you. So in the reality, you know, and the reality is that you don't really know the true reason. Okay, you don't really know the true reason in terms of, you don't know every piece of medical evidence that Social Security had to be able to say that your situation is exactly like theirs. Now I'm going to go back to Markel's question. He asked, he or she, don't know which one, so I'm just going to throw it out there. Friend who is a veteran who just became 100% disabled and wants to apply for SSD, should he contact the lawyer first and go and apply on his own? Question, because I tell people all the time, it really depends on what your personal preference is. And this is, and it's kind of funny because you would say that, well, as an attorney, well, what would you recommend? I'm like, you know, this is the way I look at it. And this is not me being funny, but I want you to follow the logic. Most people ask me, do I need an attorney? And I tell people all the time, okay, thank you, Markel. Markel's question, I tell people all the time, you don't need most things. With the exception of food and water, there's few things, food, water, shelter, there's very few things that you need. So let me kind of break it down to a different level. Let's ask yourself this. If your car broke down, do you need to hire a mechanic? Not necessarily. If you know how to fix a car, you could go out there and you can handle it yourself. Let's say that you think your clutch has slipped on your car and that you need a brand new clutch. Do you need a mechanic to repair it? If you know how to do it on your own, knock yourself out. The kicker becomes, if you don't know how to handle it on your own, the question then becomes, are you willing to, do you have the time, energy, and the ability to figure out what needs to be done, what tools you need, what parts you need, how long it's going to take. If you have the time, energy, and the availability to do all those things, you may be able to do that on your own. But some people are not. So, like, for instance, I will tell you, I'm not mechanically inclined. So guess what? If I hear something weird in my car, am I smart enough to learn how to fix it? Sure. I ain't got no time to go out there and try to figure out how to fix the car. So guess what? Around the corner I go. So I say all that to say this. It really depends on how comfortable you feel handling the process on your own. If you feel, Markel, that if you feel at the grander scheme of things that, or the person feels that he can handle going through the disability process on his own in terms of getting the medical records, filling out the forms, answering any questions, by all means, if you can do it by yourself, knock yourself out. However, if there's a point where you believe that it's in your best interest because that you don't want to take any steps that might hurt your case, by all means, there's plenty of resources out there. National Organization of Social Security Claimants Representatives, the National Association of Disability Representatives. Both of those organizations have a wealth of representatives who are available to assist you. Your local bar association, heck, you can just go on Google and find them. Now, George asked a good question. What is the percentage of people losing benefits to review? Let me give you the short answer. I don't know. Now, because you're asking, it's a twofold question. Meaning, how many people are actually going under the review process? How many people are in a position where they are now looking to possibly be turned away as a result of review? Either way, I don't really answer the question because it's a person-by-person question. The key that I would like to throw out with regards to George's question, and I've talked about this as well, and this is something that I stress to people, when you get on disability benefits, you need to think about it like this. I know that you're going to be thinking about trying to improve your situation because most people, you'll do better going back to work than you will be getting disability. But here's what I need you to keep in the back of your mind, okay? At the end of the day, the moment you get on disability benefits, you have an ongoing duty to continue to prove you are disabled. So please don't think that just because you get on disability that you're going to ride off into the sunset unless you're like 64 or 65 and you're knocking on retirement age. So there's always the possibility that your case could be reviewed, and there's always the possibility that your case could be determined that your condition has improved to such a level where you are no longer disabled. Always keep that in your mind. All right. How long for SSI to calculate my workers' comp and my SSD? P.S. It depends on how much information they need, and it depends on whether they get it in a timely fashion. And you say, what does that mean? Well, if they're calculating your workers, if there's a workers' comp aspect to it, and they have to factor in that with your SSD as well as with the SSI, if they have to factor all of those things in there, it may take a while. And you say, well, what's a while? It really depends on how soon they get the information they need. If they have to contact your workers' comp carrier to get the information and they're slow, if they have to contact the workers' comp attorney and they're slow, if they have to contact your workers' comp, your attorney, and they're slow, guess what? Your pay is going to get slow, because they're not going to release any money until they get all those calculations taken care of. The sooner you get that information to them, the faster they can calculate. What is considered an unsuccessful attempt to try and work? Rule of thumb is, I believe it's less than 6 months. But I always tell people that the way it's kind of weird. Usually the best is under 3. Once you get to 3 to 6 months, they're more likely to not look at it as what we call an unsuccessful work attempt. Kyra is asking the question, what's called an unsuccessful work attempt. That's typically when you are entering into the workplace to try to work, and as a result of your conditions, you're unable to work, so you stop working. So you ask Social Security to look at that as what we call an unsuccessful work attempt. I typically say to people that the closer you are to the less amount of time, the more the courts or Social Security may look at it more favorable as to a longer period of time. What does that mean? Well, if I have to look, because I haven't looked at the unsuccessful work attempt in about a little while. It used to be anything under 6 months, but the threshold cut was 3 months. What does that mean, threshold cut? Which basically means that they look at it more favorable to you in terms of an unsuccessful work attempt if it's less than 3 months. Once you get to 3 to 6 months, not necessarily as much. Okay? All right. How will the upcoming appeal of Obamacare affect Medicare? Markel, don't take this the wrong way. No way to answer that question until it actually happens. So I hate to put that in there. Okay? Why did my workers' comp pay become taxable when SSDI started paying me a partial payment? To be very honest, I have no idea why your workers' comp became taxable, because I don't deal with workers' comp. So you probably need to speak to either a workers' comp attorney or IRS, one of those two, and they can break that down to you. But I couldn't really give you a definitive answer as to why your workers' comp became taxable when SSDI started making you a partial payment. And so again, finishing up my original discussion in terms of focusing on your case. Okay, as I indicated before, when you're talking to people about your disability case, okay, you don't know when somebody else was approved. You don't know why somebody else was approved. You don't know which workers worked on their case. You don't know every piece of their medical evidence. You don't know specifically what Social Security relied upon. And finally, don't focus on it so much, because if you focus on why somebody else got approved and not focus on building up your case, you will stress yourself the hell out. Now let's kind of go back here with the last few minutes, because I got another question in here. The 24th of this month is going to be 60 days. Do I contact SSI after that date? You can contact them at any point in time. I typically tell people that 60 to 90 days is usually the rule of thumb. And they'll probably tell you that depending on what they have already, don't be surprised. That's the response back that you'll get. But you can definitely reach out to them after the 60-day mark and ask the question, hey, what's going on? If you haven't received any written correspondence at this particular point in time, you should have received some that gives you a breakdown as to what's going on with your case. But yeah, by all means, if you want to give them a buzz to find out what's going on with your case, please, by all means, reach out. All right, also, to go back to the original point again, as I was discussing, when you're going through the disability process, it is so easy to listen to all these people giving you their guidance and their feedback about why they believe your case is denied or delayed or why and everything like that. And it's very easy to get frustrated when you're listening to someone else who makes it appear as if they did everything right. Let me say this again. It's easy to get frustrated when you're listening to other people who will give you the idea that they did everything right, and then you are doing exactly what they're telling you to do, and you're not getting the same result. Be careful. Be careful, because it is so easy to get caught up in the glow of that. And because you've spent so much time getting caught up in the glow of that, guess what ends up happening? you allow yourself to get so frustrated over the situation that it adds stress to your situation. Don't let it get like that. When you're working on your Social Security case, focus on your Social Security case. Don't focus on the fact that someone else had a different outcome or had a favorable outcome. Don't do that. Because if you do that, what's going to end up happening is you're going to be in a situation where you are going to be so stressed out and so upset because they had a favorable result. You didn't get a favorable result. And guess what? Now you find yourself in this situation where you really are mad at the world because you just don't make any kind of sense that they got approved for disability benefits and you did not. Social Security does this on a case-by-case basis because the reality is that, think about it. Are you going to the same doctor as that person? No. Same clinics? No. Same hospital? No. Even if you are you being treated the same way? No. Are you getting the same medication? Same dosage? Are they adjusting it the same? Are they sending you for follow-ups? There are so many things you don't know that don't let the things that the people who are telling you about this allegedly, do know affect you. Okay? Now, PS is asking, does my attorney get paid first than me? I said it just depends. It depends. And the reality is that it usually is easier to release attorney fees to the attorney first, because the way if I remember correctly, somebody broke this down for me a long time ago. They were like, the way the regs work is that attorney fees are protected so that they are paid first. And that's done. And sometimes when I have people get mad, why doesn't my attorney get paid first? I said, because you know what Social Security did? Social Security recognized that in order for people to get the representation they need, they had to protect attorneys. Because if they don't protect attorneys, what ends up happening is clients don't get the representation they need because attorneys are business people. They make a determination that maybe it's not in our financial interest to represent someone if they're put last on the totem pole for getting paid for the work that they've done. Because they're usually in the case just as long as you are, of course. And the last thing, and this is kind of even more fascinating, because years ago it used to be disability insurance benefits, SSD, was protected, meaning you got paid if you won those cases for your clients. SSI wasn't, which means that if you won a case for somebody on SSI only, you had to rely on the person who got their money to pay you. And you'd be surprised the number of times people, when they get the money, would choose to not pay their attorney or want their attorney to get paid on a payment plan. I had that happen a few times. And so what ends up happening is that representatives make a decision. They're like, you know what? If there's no way to guarantee that I get paid, then it doesn't make sense from a business sense to represent someone. So the reality is that there is a possibility that the attorney gets paid first. The other thing I tell people is that usually when the attorney gets paid, the person usually gets their money released fairly shortly afterwards. But that's only unless there's no weird stuff going on, like a workers' comp offset or some child support that's outstanding. It's like all these weird little things that occur. All right. What are the chances of getting a favorable decision without a hearing? Kyra, I'm going to break this thing down. It's going to sound weird. Follow with me if you can. When Social Security is trying to make a determination at the hearing level about making a favorable decision in your case, what they're basically looking at is, do they have a substantial amount of evidence or sufficient amount of evidence that supports making a favorable determination without having to call you in for a hearing? If they don't believe they have a sufficient amount of information in order to do so, they're not going to do it. So the reality is that it's kind of difficult to answer the question what are the chances, because it really depends on what's in your medical records. One of the things that I just had, it's funny you bring this up, Kyra, because I just talked to a client about about this yesterday. And this is what I tell them. I said, when you're going through this, two things that they're looking at. Is the file completely up to date? Meaning, is every piece of evidence that's outstanding relating to your case in the file so they can look at your file one time? Not just trying to look at it and what they have in there already, and you got a few out there, but the stuff that you're saying is there is good already. It's not how it goes down. They want to make sure, do they have everything in your file already in order to render a favorable decision? That's the first step. Okay. Second step they look at is there anything, they want to make sure that there are no problem areas in your case in order to make a favorable decision. What do you mean by problem areas? Well, like let's say, for instance, you have breathing problems, but you smoke. Let's say that you have depression, anxiety problems, but you use drugs and alcohol. Let's just say there's a gap in medical treatment where you didn't get treatment for like a year. Maybe there's a period of time where you actually return back to work. So guess what? If there are all these little problem areas that need to be addressed, guess what they're going to need in order to address them? They're going to need you to address them. So if you can't, if you're not able to address them ahead of time, you're going to have to do that at a hearing. But if there are those problem areas that are on your case that needs to be addressed, they're not going to, they're probably, I'm not going to say that. I'm not going to say definitively because nothing's definite, but it's more likely than they're probably not going to render a decision favorably for you without a hearing unless you address those things. So it all goes, when people ask me the question, what are my chances? I said, I always tell them it all depends entirely on what's in your medical records, because your medical records will really dictate what happens next with regards to your case. All right, everybody. It is 4:30 p.m. Eastern Time. Just want to give you a friendly heads up. I'm doing a new experiment because I'm trying to find the right balance of my cases, right balance of shows and everything. For the next month, for the month of March, I'm basically going to be uploading 3 videos a day on Monday, Tuesday, Thursday, and Friday. 1 video on Saturday and Sunday. And then I'm also going to do a live show every Wednesday at 4 p.m. Eastern Time. So hope this helped you guys out. Keep the questions coming. Hope you enjoy the videos coming up. And I will look forward to seeing you next week if you have any follow-up questions. And keep it rocking and locking here on Disability Talk Live with me, Attorney Anthony Reeves.